Thank you. Welcome to our interactive stage, DPIA, Data Protection Impact Assessment in Practice, the typical hurdles and some remedies I want to propose to you. As mentioned earlier, for some of you who just hopped in now, please address or feel free to address all of your questions in the chat. We will have enough ample time at the end of the slot to discuss and speak about your questions in order to have a free flow of speech. We decided to put your question and have the Q&A at the end. So yeah, interesting topic, and here you see the agenda for today. So I picked up two important subtopics of a data protection impact assessment. One is the PTA, the privacy threshold assessment, and the other is, you know, a little bit the dispute over methods. As you might know or might be aware of, there are different types of method how to conduct and carry out a DPIA, and I want to give you a short overview of pros and cons and some challenges in practice. So yeah, let's dive in and start with the privacy threshold assessment. So if you want to carry out a data protection impact assessment, you always have the hurdle, okay, when do I need to carry out a DPIA? And the GDPR is in this respect quite clear. It says, okay, a DPIA needs to be carried out when where processing operations are likely to result in a high risk. But what the GDPR doesn't say is, okay, when is this high risk imminent? So it doesn't quantify when the threshold of the high risk is met. And in order to do so, you need to carry out a privacy threshold assessment. So the PTA is an integral part of a DPIA life cycle, and that's what some practitioners don't know or tend to forget. So if you do not carry out this kind of mini DPIA before the ordinary DPIA, then you might miss an important step of the life cycle, and respective supervisory authorities may conceive this DPIA not fulfilling all, you know, mandatory steps. So yeah, a PTA is very important. The GDPR in its recitals, as you find on the slide, it says, okay, the risk evaluation needs to be based on an objective assessment by which it is established whether data processing operations involve a risk or a high risk. So out of this recital, it is clear that you need to do a PTA. And what some practitioners find quite struggling is that, okay, risk from a GDPR point of view, but also in terms of information security, is always the product of the risk level or severity on the one hand, and the likelihood that this risk materialized on the other hand. And in a PTA, obviously, you cannot assess both. If you do so, then you already carried out a data protection impact assessment. So it's common sense and to some extent best practice if in a privacy threshold assessment in prior to a DPIA, when you assess whether a high risk is occurs or not, you would only look at the severity. You would only focus on assessing the risk level and not the likelihood. The likelihood is a topic that you would cover in the DPIA itself. So if you are supposed to carry out this PTA beforehand, what is the criteria? The good thing is that the GDPR has some criteria in its wording already, but as you find here on the slide, there are different criteria to take into account. The first thing you always have to cover is, has a DPIA already been carried out for a similar processing operation with a similar high risk? If so, then there might not be a need to carry out a DPIA again if the processing operation hasn't changed. So this should always be the first question you should ask yourself. And then you would take a look at the published black and white list by the respective supervisory authorities, by your competent supervisory authorities, and would assess whether the processing operations falls under one of those items in the respective black or white list. Then you have also to take into account the respective 3 criterions under Article 35, paragraph 3. Those are the only criterions in the GDPR, basically. And then what you also have to take into account when assessing a high risk is the so-called 2 of 9 test. The European Data Protection Board, they published additional criteria in order to determine a high risk. You find those here, and it's published in the working paper 248. And the data protection authorities here in Europe, they say, okay, look, if 2 of these 9 criteria are met, then you should carry out a data protection impact assessment, because if 2 of 9 criteria are met, a high risk is to be subsumed. So those are the criteria PTA that you need to carry out before a data protection impact assessment. Those are the criteria you should take into account. And there are, of course, some hurdles in practice. I mean, you have now this long list, and now you have to double check, okay, is my processing operation, does it fall under one of the criteria? There are some challenges in practice. One, for example, is if you look at the GDPR at Article 35, it says processing operation. But what is a processing operation? As a lot of terms, it's not defined in the GDPR. It can also not be subsumed under processing activity. You know this term as it's laid down under Article 30 when it comes to the records of processing activities. So the German Conference of Data Protection Authorities defined it as sum of data systems, hardware, software, and processes. But as you can see, the term is quite broad. In my opinion, the reference point in practice should be the overall purpose of processing. So if a processing operation forms an inherent context, then you can bundle different processing activities in one DPIA, and that's then the processing operation. And if you look in recital 92 of the GDPR, this recital allows for a broader DPIA scope. Another hurdle or obstacle in practice is the granularity of the EDPB criteria. There are different types of criteria, but there's no objective scale of weighting. Let me give you an example. So if you process 1 million IP and email addresses via blockchain and transfer it to a third country, then you would meet 3 criteria of this working paper 248. But compared to just processing the genetic data of 50 people here in Germany, only 1 criteria would be met in that case, and we just assume that this 50 people are not considered, you know, as a high amount or high scale of processing of special categories of personal data as outlined under Article 35, paragraph 3. So in this example, you see that you need to weight these criteria to some extent, because obviously processing of this 50 genetic data, these data sets, they impose much higher risk for the data subjects than merely processing way higher amount of IP addresses or email addresses. So the 2 out of 9 test is good, but as you see in the slide, in my opinion, it's too sweeping and not selective enough. Also, you should, or you need to consider additional criterions as well in order to carry out a holistic risk assessment. You should always ask yourself whether the data subject can avoid or evade the processing of their data, because that's an important topic for assessing the risk as well. And also whether third parties are involved in the respective data processing at hand. So you should take into account these additional criterions as well in order to have a really holistic risk assessment. So that's for the PTA, a short overview only, but I think I gave you some impressions how to conduct it in practice and what to look out for. Then dispute over methods. There are a lot of methods proposed when it comes to a DPIA. And I picked 3 methods I found quite common in practice as a external data protection officer. I get in touch with a lot of controllers and processors, and in this respect see how they try to tackle DPIAs. And I picked these 3 methods. The first is the standard data protection model that has been established by the German supervisory authorities. Then it's the PIA tool by the French data protection authority, CNIL. And then there is the ISO 29134. As I mentioned before, there are other methods as well. The ICO, for example, has published a questionnaire. Business associations like Bitkom have published an extensive white paper on this topic that is currently under revision. And also NGOs have provided good content. For example, Forum Privatheit here in Germany have also published a quite good white paper on this topic. So there are a lot of methods, but there's no common method, and or no method that supervisory authorities have agreed on as the typical or best practice method. So we have to look in practice what to use. And if you want to start a DPIA, you have to consider, okay, what kind of methodology do I want to follow? So in this respect, there are always pros and cons. If you take a look at the SDM from the German supervisory authorities, it's a very, very comprehensive model, and it really puts a focus on methodology, and a systemical approach. It is aligned with the GDPR, which is always a pro, but on the contrary, it's quite hard to use, in particular for SMEs. So it is good for, you know, an educational and a research purpose, and also big multinationals have the power, you know, have a legal department, have a compliance department, even have a data protection or a privacy department, so they can cope with such complex model. But for the ordinary controller, it might be quite hard to implement. And another factor to consider is that it's not widely accepted across Europe. To the contrary, there is the PIA tool by the CNIL. It's very practice-oriented and user-friendly, and it's a software which enables controllers, you know, to scale the DPIA. It's available not only in German and English like the SDM, but in several languages, and it's open source. So you could even adapt it to your personal needs and IT framework. The downside is it has certain methodological shortcomings. To some extent, it's erratic. It doesn't include a PTA. And as I just said earlier, PTA is you know, required in order to assess whether a high risk is most probably involved in the processing or not. And also there are only 3 security goals covered. So as you know, there are several security goals. The GDPR in particular names integrity, confidentiality, and availability. This is covered by the CNIL tool, but for example, resilience is not part of the tool, but it needs to be a part of a holistic risk assessment as well. And then there, between those, you know, extremes, very hands-on software on the one hand, and a very systemical approach with the SDM on the other hand, there is the ISO 29134. It's internationally accepted. It has a proven systemical approach and methodology, but it's still hands-on. The biggest downside is that it's not aligned with the GDPR. So it has a broader scope, and you need to take that into account. How do we tackle at DataGuard with this issue? So we took the CNIL software, because a software solution is always the preferred option when you deal with a lot of processing and with kind of commodity work like DPIAs. And in this respect, we took the CNIL tool and added respective items from the SDM and the ISO 29134 to have, you know, a very holistic risk assessment software. And this is how we tackle the DPIAs for our clients. Just the last minute, and then we can hop into the Q&A. What are common obstacles here or challenges in practice? As you could see, there are different methods and there's no real harmonization here in Europe. So it would be really desirable if the European supervisory authorities would say, okay, this is our preferred method, or at least say, okay, these 5 methods, if you carry the DPIA out using one of these 5 methods, then it's okay from a systemical point of view. Then there are other few topics, for example, and this is also very relevant in practice. What do I do in case of joint controllers? This topic is, for example, not covered in any of the methods, and the only practical solution is that one of the joint controllers has to carry out the DPIA for all other joint controllers. There are, you can argue with recital 92 of the GDPR in this respect. And what is also important in practice is that there is a need for sample DPIAs. So either supervisory authorities, and the supervisory authority of the Netherlands, the Dutch one, did it last year, and German ones did it this year with the Corona tracing app. They published DPIAs, so we practitioners can see what is expected from a DPIA, but also the big service providers, the big processors, they should disclose their internal DPIAs for their products. Best practice example is Microsoft. They published DPIAs for their different software, and this is something we need more. So as a controller, if I use a certain software, it's way easier to carry out a DPIA if I have, you know, the DPIA ready at hand of the respective processor. So just food for thought. The respective slot is now from the content side over, and I'm happy to address your questions. So the first question is whether the presentation will be available afterwards somehow. I think it, as per usual for our Bitkom events, there will be a download section where you can download the presentation, but you can always send me a message. My contact details are available in the app, so just ping me and I can forward you the respective presentation immediately. Okay, that's it for the questions. I don't see any additional questions. If you have any questions, then feel free to address them now or ping me. I'm happy to provide additional information or discuss with you over certain topics.
Okay, I think there are no other questions, how it looks like. And as I wrote already, everything will be available on the event platform in the next couple of days to download.
Okay, there's another
Yes.
question. DPIAs should address risks to fundamental rights. Does that ever come up explicitly? So, yeah, well, the entire GDPR is based on fundamental rights, but when you do the risk assessment, you have always, you know, the respective security goals, as I mentioned earlier, that you wanna, you know, protect in particular. So you wanna make sure that integrity of data is maintained, so that data isn't changed unauthorizedly, that confidentiality is safeguarded, so that data is not disclosed to parties that should not become aware of that data. So from a risk assessment perspective, you would always assess whether these goals are met, or to what extent these goals are met. But these goals in the first place are obviously based on the fundamental rights, but you cannot in a very generic risk assessment take it to this high, broader meta level. So I hope this question is addressed properly. Okay, another remark. I would have wished the scalability and standardization challenges would have been addressed in the presentation, given that a PTIA needs to be carried out within each and every assessment, regardless whether a DPIA is later required. Well, that's for sure. I mean, in 20 minutes, you can always pick out certain obstacles and hurdles in practice. And since not everyone has carried out a DPIA and a PTA, I tried to cover topics that everyone can relate to and is able to understand. But obviously this is a very, very big hurdle and obstacle in practice, that you need to scale it, and that you need a standardized approach. That's why I try to outline certain criteria that you need to include in a PTA. But since most models or methods I explained earlier don't really cover a PTA, it's quite hard to find a common solution. Okay, I think the time is over and the other slots are starting now. If you have additional questions or remarks, please always feel free to address them here in the chat or via email or in a private chat to me. I'm happy to get in touch with you. Thanks for staying tuned for these 30 minutes. I hope you took a little bit of what I've presented to you and incorporated in your daily practice. DPIA is an important topic, is a topic that is not in focus as it should be to some extent. So yeah, happy to get in touch with all of you later if you have any remarks or questions. Thank you very much.
Thank you, Dr. Schemmel. Thanks, everyone.